Namaste to all the participants in this International Virtual Summer School of 2021, organized by Nivaaran-Mediators of Supreme Court of India. Today, we are almost in the last leg of this summer school. Through this week-long in-depth deliberations over various aspects of mediation by our honorable justices and judges, esteemed guest speakers, and also through the thought-provoking questions from our participants. It's been a great learning experience that has amply enriched our participants' knowledge about ADR or alternative dispute resolution. We have seen how with the advent of adjudication, where one size fits for all, the stakeholders of our justice dispensing system slowly distanced itself from the litigants' pain and wants, while parties' interests took a backseat. But now with our Honorable the Chief Justice of India, Shri N.V. Ramana, reiterating that future belongs to mediation, Nivaaran's hope is high. This morning's news report about Honorable CJI mediating between a couple in marital dispute over 20 years and reaching settlement is further proof of this conviction. In the inaugural session, he said, mediation was a practice that was commonly followed in India prior to the arrival of the British and their court system. Not only did the British establish the framework of the modern Indian judicial system, but they were also instrumental in the creation of the myth that dispute resolution and justice requires black coats and gowns and elaborate arguments. It is time to dispel such myths and notions, I unquote. So here is Nivaaran taking the mantle and marching ahead with the inspiration and support from the guardians of justice in India to fulfill the long neglected aspirations of those to whom the ray of justice failed to reach, working incessantly for the advancement of amicable settlement of disputes through mediation and ensuring greater access to justice for common people. As far as ADR is concerned, COVID-19 has literally pushed us to go online and to communicate, to settle our disputes also online. And this is ODR in simple terms. ODR successfully blends information technology and alternative dispute resolution mechanisms together in order to resolve disputes efficiently. Both technology and the dispute resolution mechanisms are now the two pillars on which ODR has developed. When the world was getting introduced to internet in the 1960s and 1970s, the world was also witnessing dissatisfaction with the court systems all over the world. The caseloads were increasing many-folds with each passing day, and much more was expected from the institution responsible for delivering justice. This discontent with the formal court systems led to the convening of Pound Conference 1976. The idea of ADR has gained momentum since then throughout the world. ADR was not just an efficient way of resolving disputes. It has also come as a tool to change people's mindset about disputes and resolving it by looking at the bigger picture. Today, we will understand how this technology, this mindfulness of resolving disputes together in an online setting will become the norm in the future. We can say that ODR is the new legacy coming out of this pandemic. After all, we have understood that resolution, particularly pre-litigation redress, is more effective and much more scalable and efficient in resolving cases. ODR is not just dispute resolution, but dispute prevention process as well. So need of the hour is to create awareness on a big scale. The best way to create a successful ODR environment is to build a mindset for mediation. The need, therefore, is to build an effective, autonomous ODR ecosystem. Suggestion is a float for a mediation app fully loaded with artificial intelligence and machine learning tools for the use of all. And given the proven success of many other apps in use today, there is no doubt that our people will lap this up too. Some of the artificial intelligence tools already in use in many countries abroad are Smart Settle, Family Winner, automatic translation, automatic summarization, etc. However, taking mediation into a completely process-driven environment where there is no video, interface, or voice exchange, maybe the time of such robotic ODR process has not come here as yet. We still prefer video conferences, voice calls, where people can create digital empathy via connecting with each other. And here the important aspect is emotional quotient. Whether it is $1 billion stock market deal gone wrong, or your separated spouse does not allow you to access your child, or married sisters hoping to get a share to their parents' property, legacy, everywhere emotion plays a big role. We must remember that corporations are, after all, run by human beings. Intrapersonal or interpersonal relations do matter everywhere. So having emotional intelligence is extremely important. A mediator must have the capacity to read the body language, feel the air and energy around, be it through the voice call or a video call. ODR is here to stay along with face-to-face ADR for sure. Actually, it is the ability to empathize with the other person that is important, whether it is face-to-face or through online. Time zone, computer screen, etc. do not matter. We can always continue to empathize, continue to dialogue, continue to share, and continue to learn. Mediator mindset is what is needed. With this thought of mine, I am happy to announce that in the coming 45 minutes, we will go through the pros and cons of ODR, and thereafter we will interact via question-answer session. Today, our honored guest speaker is Ms. Gunavathi Subramanium from Malaysia. Welcome, ma'am. But first, a quick introduction of myself. My name is Sangeeta Mehrotra. I have a diverse background that includes studies of law, literature, history, religion, philosophy, ADR methods and practices, along with public relations management and marketing. I gained this experience through my undergraduate and postgraduate education, extensive interaction with people during my 36 years in legal profession, and over 250 hours of professional training as a mediator under various recognized national and international institutes of repute. Today, I am humbled being chosen by Nivaaran to host and moderate this session, where Ms. Gunavathi Subramaniam, an advocate and solicitor, a mediator at Malaysian Mediation Center and a mediator trainer par excellence, will enlighten us with her views on online dispute resolution and its advantages and disadvantages. Ms. Gunavathi has been in legal profession since last 34 years. She is the pioneer mediator in Malaysia with more than 20 years of experience in alternative dispute resolution methods. She drafted the mediation rules, code of conduct, accreditation guidelines, and Mediation Act for the Malaysian Mediation Center and deliberated on the Mediation Act with the Attorney General's Office. She is passionate about mediation and she promotes mediation as a premier technique for dispute resolution internationally and in Malaysia. She has thus far trained more than 800 mediators, including a broad spectrum of professionals, and for the past 2 decades, Ms. Gunavathi has lectured at the Faculty of Law, University Malaya, the country's premier university, for the Masters in Laws program in Alternative Disputes Resolution. She is much sought after speaker who has delivered papers at national and international conferences and webinars. She is an active member of an international mediation organization called Mediators Global Group and has participated as an expert in providing mediation training to the Swiss-Chinese Law Association. In September 2020, Ms. Gunavathi participated as a panelist and speaker at the International Webinar on Post-COVID Mediation, Charting the Path of the Future, organized by our Honorable Supreme Court of India and the Commonwealth Lawyers Association. I urge our young participants to make the best of this session. So here I welcome Ms. Gunavathi to take the floor.
Namaste, everyone. Sangeeta, thank you for that wonderful introduction to ODR and myself, and a little introduction about yourself. I think you have pointed out very salient factors of what ODR is. However, I think I would still like to start with what is ODR and a little bit about the background of ODR and the history of ODR. So if I may share my slides now. Yeah. But I can't move. So I'm at the first slide. The second slide, sorry. Not the title slide. Rahul, can you move the slide, please? Right. So this is our agenda for today. We're going to talk about what is ODR, followed by a little history of ODR, and what are the types of disputes which can be settled by ODR. I know our topic today is online mediation, but ODR is the big umbrella of online dispute resolution, and online mediation is one of the processes within this big umbrella of ODR. Then we move on to the ODR mechanisms, followed by the processes. Then we dive into the topic, today's topic, which is the advantages, followed by the disadvantages. And I would also like to share a little bit about the impact of artificial intelligence on ODR. And lastly, end by speaking about what is the future of ODR. Next. Right, so now what is ODR? So very simply, ODR, as I said, runs as a parallel justice system to the traditional court system. So it blends information technology and dispute resolution mechanisms in order to resolve disputes efficiently. So basically, it is facilitated by information and communication, and information technology. So this is how one would define what ODR is. As I said, online mediation is just one of the mechanisms. Next. We will talk about the history of ODR. Now, as what Sangeeta pointed out earlier in the introduction, ODR has been in existence for more than 20 years, about 26 years. So how did ODR come into existence? So why was it needed? So in the 1990s, the online environment for commerce, education, employment, and entertainment was a boom. So this was the era of commercialization of the internet, and businesses were given more power. So an increased interaction resulted in an increase in disputes. So the online world saw an increased disputes ranging from spamming, phishing, illegal downloading and piracy to normal commerce of buying and selling online. So they realized that cyberspace was no longer a harmonious place. So in the 21st century, internet became the engine for introducing modern technological solutions for almost every activity, including legal services. So parallel to when the world was getting introduced to the internet, the world was also witnessing dissatisfaction with the courts globally. So there was a huge backlog of cases which led to the discontent of traditional court system. And like what Sangeeta pointed out earlier, this led to the Pound Conference in 1976, pressing for ADR mechanisms for resolving disputes amicably, which focus on the needs and interests of the parties rather than the rights and obligations of the parties. So as online activities grew, ODR emerged as disputes grew as well, naturally. So internet was part of the problem, I would say, in generating disputes, but it was also part of the solution in garnering resources to resolve it online. So the first commercial spam occurred sometime in April 1984 when two lawyers tried to recruit clients to participate in an immigration scam. And in September 1984, the US Federal Trade Commission filed its first case of online fraud. So this was way back in 1984. And we're just starting to talk about this topic now here in Asia. ODR started gaining momentum when the first ODR conference was held in 1996, sponsored by the National Center for Automated Information Research, which also funded ODR projects like the Virtual Magistrate, Online Ombudsman at the University of Massachusetts. So the first big players in the field were actually big online retailers that most of us are familiar with, like eBay and PayPal. So these online vendors realized that they needed a means of resolving disputes involving small amounts of money between parties who are separated by distance because all their transactions are done online. So these online retailers realized that a low-cost means of resolving customer disputes would be a key component to the growth of online retail. So what they did was they started launching platforms that were user-friendly and programmed to be neutral, providing the parties with human input if the online process proved less than satisfactory. And the big breakthrough happened in the field of ODR when eBay was founded in 1995, when they put a feedback system where buyers could know more about the seller. This was in order to generate trust and risk reduction. So this feedback, which they did, was a big step in generating confidence in the buyers and also eliminating disputes between buyers and sellers. And subsequently, in 1999, eBay asked the University of Massachusetts to conduct a pilot program to mediate disputes between buyers and sellers, which turned out to be a huge success. And it handled, at that time, about 200 disputes online in a 2-week period. So thereafter, eBay included dispute resolution as an option for buyers and sellers for unsuccessful transactions, making it the first company in the world to do so. And by 2010, the number of disputes resolved online by eBay had reached about 60 million. And in 2016, at the ODR conference, eBay's ODR was ranked as a trendsetter in the field of ODR, which prevented about 90% of the disputes from going to the courts. So it was actually a huge success. SquareTrade.com was selected as eBay's service provider. So SquareTrade maintained the ODR platform for eBay. And this was before appointing a human mediator. A technology supported by negotiation process was set up for parties to resolve the disputes. So there was no human element at the beginning. It was all just machines. So they employed the web rather than email as the means of communicating with and working with the disputants, as most people would have reached an impasse by negotiating via email. So once there was an impasse reached, they moved to this platform. So the mediator then is only appointed if this fails, and of course for a fee. Nothing is free. There's no such thing as a free lunch. So this ODR platform, eBay's ODR platform, became an inspiration for other countries to follow suit, like in the UK, China, Brazil, and some EU nations. So ODR in its current state is being used as a hybrid mechanism by various institutions around the world. So, but currently, the World Intellectual Property Organization and the National Arbitration Forum have online systems where emails are sometimes used as well. So basically, that is the history of ODR and how ODR was launched by eBay by using their own service provider. Now let's move on to the types of dispute. Can we move to the next slide, please? So ODR can take place entirely or partly online, and it concerns two types of disputes: disputes arising in cyberspace and disputes arising offline in the real world. So ODR resources are used alongside traditional ADR processes to complement and enhance those processes. So ADR processes were still there. So this ODR processes may be facilitated by negotiation, online mediation, and determinative mechanisms such as online arbitration or online adjudication. Now let's look at the mechanisms. So there are two forms of ODR mechanisms. One is synchronous and the other one asynchronous. So of course, both involve service providers. Synchronous meaning this is done in real-time communication by video conferencing, teleconferencing, chat rooms, where you can use apps like Zoom, Teams, Skype. Yeah, but of course, the most common one I think is Zoom. Yeah? And I use Zoom for my online mediation disputes as well. And for the synchronous mechanism, email communications are used. So what happens is it is all done by email. So documents and bundle of documents are scanned and shared via email and or instant messaging. So it's mostly done by email, but what happens here is that because it's asynchronous, there's a time gap. So what happens is the service provider will send an email to the parties to exchange documents. And after that, they start the communications. They fix a date for parties to give a factual summary of what has happened. They exchange the summaries, and then they start the communication by way of email. So there is a time gap here, because when the mediator or the service provider receives email from one side, he will have to then wait for the other side to reply, and so on and so forth. So that's how the mediation goes on via email. I will talk about the advantages and disadvantages of this method later. So let's move on to the ODR processes which are available. Now, some of the early ODR mechanisms which were used were automated negotiation, or what we call blind bidding. Now, these are actually fully automated cyber negotiation websites such as CyberSettle, Settlement Online, and Click and Settle. So participants, you can Google and check all these websites out. Yeah? So these websites offered services that were entirely online and focused primarily on negotiating monetary settlements. So these websites served as a neutral arena to exchange settlement offers. So what happens is an aggrieved party initiates a claim by logging onto the service's secure website, and the service then emails the other party to let them know that there is a settlement proposal and gives that party access to the website. So that party accessing the website can either accept or decline to participate. So if they decide to participate, they can log on to the website and submit a demand. The computer software automatically compares the demand with the settlement offer and emails both parties to let them know whether they are within the range of settlement. So some of these websites allows 3 rounds of bidding, or some allow only 2 rounds of bidding. So it depends on the service provider. So if no settlement is reached, the offer remains confidential and parties can proceed with traditional litigation or arbitration. So these blind bidding websites are suitable only for purely numerical interests, like maybe in insurance disputes. Because if liability is in question, then automated negotiation or blind bidding is definitely not suitable. It's not a suitable forum. Okay? Next is assisted negotiation. So this is done with the assistance of a third party and using online facilities. So communication here is done via web-based communication tools, video conferencing, and email. So service providers offering this service will offer directives for developing the agenda, so setting the agenda, identifying the interests of the parties, and assessing the solutions and agreements. So the service provider has the responsibility to manage the storage of documents and the security for these sites. Next is online arbitration. Now, electronic arbitration, the process is actually similar to traditional arbitration, but it's done online. So it can include, for example, downloading of forms, extensive use of email for communication and submissions, exchange of documents, because normally for arbitration, there's always an exchange of voluminous documents, and the use of video conferencing and virtual meetings. So now these services offer paperless case submissions because everything is sent, the documents are bundled and sent via email and submitted. So because it's all submissions, electronic submissions, it is normally done by secure email. And obviously the awards handed down by the arbitrators will also be done electronically. So normally these are used for disputes involving commercial matters. Now we come to the topic of the day, which is online mediation. Now online mediation is similar, the techniques used by mediators is similar to traditional mediation. That is mediation with the assistance of a neutral and impartial third party. So this process, we normally use, as I said, platforms like Zoom, Skype, Teams, or if parties do not have devices like a laptop or a tablet, then this can also be done by voice calls or chat messaging, teleconferencing. Yeah, so you can opt for different methods. Now, how is online mediation run? Can we move to the next one? Let's talk about the process of online mediation. So initiating the process is actually fairly simple. All one needs to do is contact a service provider, do your self-registration, enter the individual's credentials, and normally service providers will require a factual summary of the dispute. And the service provider will then may also include questions about the parties, the sums involved, what is the claim about, and whether they've had previous settlements. Then the service provider will contact the individual to discuss the date, the time, and technicalities basically, and the fee as well. And when do they pay the fees, etc. So some service providers actually offer free downloadable guides to interested individuals. Now, service providers for family disputes have a very simple modus operandi. So both parties are required to have access to a stable internet connection and a device with a camera, a microphone, and subscription to video conference applications like Zoom or Skype. So it's simple because you don't have to give a factual summary and etc. So for commercial dispute service providers, they may have their own applications for the mediation session to make it more secure with their own password, etc. So these video conferencing platforms offer high standards of privacy and security to facilitate the exchange of confidential information between parties during the online session. Online mediation, like normal mediation, is also a party-empowered process. And that is why I believe so strongly about mediation. It gives empowerment to the individuals. Individuals make decisions regarding the duration, when they want to start, when they want to take a break, and the nature of the session. And they have the freedom to opt whether they want their lawyers with them, or if they're comfortable, or maybe to cut costs, they may not have, they may opt not to have their lawyers with them. So it's entirely up to them. So that's why it is such a powerful process, because it really empowers the individual. So typically, online mediation process is a three-way mediation. It's a three-way video conferencing between the parties. An expert online mediator will assist in providing the service. So normally the service provider will ensure that the neutral mediator who is appointed is someone who's qualified, okay, with no prior association with the individuals involved in the dispute. Yesterday I was listening into the lecture by the Singapore International Mediation Center speakers, and they spoke about ethical concerns about whether there should be, how do you appoint the mediator? So they must ensure that the mediator is not in a conflicted position, because otherwise he cannot be appointed as the mediator. So next, let's zoom in and dive into the advantages of online mediation. Now, one of the major cost savings is one of the major advantages of online mediation. One of the main benefits compared to litigation. So, in fact, this may be the only feasible option for individuals who are unable to travel long distances, or for those involved in e-commerce disputes for low amounts. So if the amount and the stakes are very low, this online mediation really makes sense, because it can really help individuals save costs. So parties also save in lawyers' fees, as online mediation can proceed without lawyers. But if lawyers are present, the fee charged by the lawyers will, of course, not be as high as conducting a full-blown trial, obviously. So if liability is determined, parties can actually utilize cyber mediation websites as well. So this is another savings. So whichever way you look at it, there's a lot of savings in costs. And there's also no need to rent a facility, because normally for normal face-to-face mediation, parties will have to probably rent a neutral facility if the mediator's office does not have the necessary facilities, like having a separate breakout room or a caucus room. So they save on rental facility as well. So this is another savings. And the other beauty about online mediation is parties can also mediate from their respective business locations or residences or wherever they are, because they don't have to move around anywhere, right? So this definitely would lead to reduced costs and the expenditure of less time, because everything is done online, documents are exchanged online and e-mediums, and it's definitely cheaper because you don't have to use the postal service to post anything. You save a lot of money. Right. Next. The next advantage is, I mean, like normal mediation, face-to-face mediation as well, it reduces court congestion. Now, especially in times of a crisis like the COVID-19 pandemic, online mediation and online hearing is conducted even by the courts. In Malaysia, before the pandemic, I just like to share with you, in Malaysia, before the pandemic, there was no online mediation at all. All mediations were conducted face-to-face. But because of the pandemic, the courts came up with the practice direction to direct mediators at the respective mediation centers in the courts all around the country to conduct mediation online. So they were a bit apprehensive at the beginning, but somehow they transitioned into online mediation quite smoothly. And so now all mediation handled by the courts are done online. So a lot of savings in time, and parties have also actually gotten used to it. Lawyers have also gotten used to it. But the only downside about online mediation being conducted in Malaysia by the courts is that lawyers are allowed to attend the mediation session with their clients. But what happens is, during the online mediation, parties come into a joint session, and somehow the lawyers are sent out during the discussion with the parties, and then they are brought in later. But typically, this is not how mediation works. Let me just tell you that. But I just wanted to share that with you. So basically, online mediation, I would say, is a savior to prevent a huge backlog of cases in the courts. And if you're going to be waiting for the pandemic to be over, I'm sure the courts' dockets will be inundated with cases. Next is time savings. ODR saves time and effort. Dispute can be settled in days or even a few weeks. I have even settled online disputes within a day. I'm sure many of you have as well, all my colleagues, mediator colleagues at Nivaaran. And the beauty about time savings in online dispute resolution for mediation is during the caucus session. Now, one of the advantages is mediator can actually devote time to one party without wasting of the other party. The other party will be sent out, the mediation room will be locked, and the other party will not be able to enter unless the mediator allows it. So that party can actually go and do his own stuff instead of, like, in a thing, he's normally pacing up and down, reading a magazine, or he's wondering in the mediation room, what are they talking about, and maybe the agitated, we really don't know. But in online mediation, he can go in thing and come back later. Next is flexibility and convenience. Now, as I said, ODR is a parties. So parties can negotiate themselves with mediator. So ODR sessions are flexible. They are not bound of evidence or procedure. So as I always tell trainees when I'm training mediation, when you're doing mediation, you throw out the word irrelevant, because you should the vocabulary altogether, because there's no such evidence or whatever which is taken into account. It is just a negotiation and a communication between the parties and the mediator. Remote mediations are very convenient, right? So ODR is facilitated from the comfort of your home, allowing broader flexibility and access. You don't have to go and get a babysit your children. You can have them in another room, and you can in one room. So no need to fight in traffic for, to get to the mediator's office for the mediation on time in traffic. You have a choice, because you're sitting in your own home at your own convenience and getting your dispute resolved. Parties will also have more options for choice of mediator. Normally, if you are looking at a mediator in a certain location, you will only this. But this one, there's no restriction. You can pick any mediator at any location. So ODR service providers 24/7, so which is extremely convenient. Parties can all hours of the day, which diminishes difficulties faced by located in different time zones. So parties are at all hours. So asynchronous communication, which we spoke about, allows parties to respond at their own convenience. The email, they can reply at their own convenience. So there are many platforms as well. As I said earlier, not only Zoom, but so many other platforms. Key is for that platform or technology to mirror the core components of face-to-face mediation. Is what we want to achieve in online mediation. It has to face-to-face mediation to a certain extent. So this parties to be able to confer confidentiality without the mediator, and for the mediator to convene plans and breakout discussions of different groups. So this is what the mediator needs to do. Next is mediation has no geographical barriers. The recognized benefit of online mediation is that disputants travel lengthy distances. I think I spoke about this just now. Because of that, ODR or online mediation capability of improving access to justice. Areas like geographical isolation, lack of options, or mobility is removed. So, which may arise because everything online, right? So you may be purchasing something from a different location from where you are in a different state. So if there's a dispute, online mediation is the answer. Is a huge benefit for resolution of cross-border. Next is ODR mediation also avoids the issue of the court has jurisdiction over a dispute. So the dispute is between people from two different jurisdictions. These disputants in online mediation can bind themselves and choose to bind themselves by consensual settlement agreement. So they bind themselves with agreements, and questions on conflict of law and justice can be done away with. Next is advantage is online mediation can be or useful when there's a power imbalance between many a time I've come across in mediations which I've conducted. There's sometimes a power imbalance which we mediators must look out. And family dynamics are complex. So sometimes disputes, if you do screening for domestic violence and actually conduct family mediation, sometimes you may not be able during this screening process. But in online mediation, the fear of that person may be removed because he can leave audio on and stop his video. So he doesn't have contact with the other party because of that fear of facing that, like in a face-to-face meeting. For example, in a sexual harassment, the victim may not want to face the harasser. So being in the room and being fearful of coming for mediation because of needing to be in the same room is resolved. Because conflict can provide a neutral physical safety there between the victim and the harasser. Next, online mediation also removes or reduces hostility between the parties. Parties may feel more because in cyberspace, tension is reduced. Being in the same room, you don't feel the tension, the dynamics are completely different in an online scenario as opposed to a face-to-face scenario. The other technology of online mediation is the ability to use technology. You have the aid of technology to help you. Online mediation platforms can allow face-to-face virtual contact and running draft provisions. So let's say they have come up with some and save it for later, and it allows for people to take less notes because everything is shared. So those are some of the advantages. Now let's quickly move on to this of online mediation. And the first is one of the main drawbacks, I would say, having access to the internet. So in villages and parties may lack access to the internet. So common issues faced by disputants would be stability and internet speed. So poor infrastructure and a general lack of awareness is another. Sangeeta spoke about awareness as well, because if you don't create availability of such a procedure, online mediation, there cannot be any mindset. So only if the awareness is created and the bench and the bar to online mediation or even mediation, face-to-face mediation is a big problem. So online mediation can be successful. It's been proven to be successful if accessibility an issue. But if parties do not have a stable internet connection, they do not have technology accessories such as a smartphone, a tablet, so it may be very difficult to participate in mediation, right? At least they should have a smartphone and done via telephone. So the is working on overdrive because of the pandemic. Even I had notations coming up saying that my internet connection is unstable. You all can hear me and I've not broken off. So low bandwidth and other technical glitches can significantly impact the effectiveness of, because there won't be a smooth flow of the proceedings. Momentum may be lost. So you don't want to have any interruptions, disruptions in the momentum. And digital divide spans across issues of connectivity, device ownership, digital literacy, and social norms. So a combination of these factors generating varying levels of digital adoption demographic groups. So awareness, as I said, is another problem. So somehow awareness has to be noted. And what Sangeeta said earlier, to quote what the Chief Justice of India has said, that he's proposing that a mediation app be created to be such a wonderful progress for India. And I think many other countries suit by, because this will give access and on the street to mediate. So service providers, the solution is for service providers that ODR platforms can be used across and by different demographic groups. If bandwidth disruptions exist, you must always have a plan B, and have a plan in place prior to the session, because then if you have any technical glitch, you can make a call. Plan with detail who will reinitiate the call or who will restart the session. Could be the mediator. Next will be trust and issues, right? You need to go backwards. Yep. Trust and rapport issues. I think trust is an important component of any dispute. It's online or face-to-face. I think the first thing in any mediation session is to try and build parties so that the parties trust the mediator, because they have never met in their lives, right? They don't know the mediator. So for them to enable the parties to have confidence in them, they need to create. So this is a bit more difficult in an scenario because it's quite impersonal. I mean, if I were to be giving this, talking at this, instead of a webinar or at a seminar on a face-to-face level, different, because there will be eye contact. I can look at the audience. I can see listening and who is not, because we mediators are trained to look out for non-verbal communication, which I think one of the earlier speakers spoke about as well. So human interactions cannot match the richness of sessions, which is actually the heart of mediation, face-to-face. But having said that, mediation works, and in the mediation, in face-to-face, get feedback on hostile environment, look at what's going around, read body language. But if you do it online, especially by way, not even by way of video conferencing, written cannot express pitch, cannot express tone, volume, personality, or other non-verbal cues. So you can non-verbal communication, which is one of the core things which a mediator looks out for during mediation. Facial expressions say a lot. Signals being sent out by the parties play a huge role in mediation. So, as Sangeeta also talked, empathy creating empathy. So when in a face-to-face session, to empathize with the parties, because you're looking at their actions, you're reading their body language, but in an online scenario, it is slightly more difficult because they stop the video because they're having bandwidth problems. That your reading of getting cues and whatnot from body language, etc. So major disadvantage. And additionally, the of online written communications that does not exist in face-to-face, because normally after a mediation, even if the mediator takes notes, it destroys his notes. I destroy my notes. But if it's by way of email, there's a permanency, there's a record, there's a record which could potentially enable a party to distribute the email communications without the knowledge of the other party. So tricky. So without trust between parties, settlement, and question is, how do you trust? Of course, there's no guarantee, but service providers have their own voluntary codes of conduct in the ODR system. So if service providers do not conduct, maybe it's time they came up with a code of conduct. Like in the US, they have a code of conduct for all the service providers, for example, Council for Online Dispute Resolution. And the proactive disclosure of I think is very important. So at least you're going to be conflicted, you have to inform the parties and recuse the mediator. Next would be confidentiality, also very, very important. I think one of the major hallmarks of mediation is the confidential process. So this ability to ensure confidentiality in ODR depends on their own as well as the design of the ODR platform. ODR principle of confidentiality must account for technical standards to ensure transmitted on the platform remain confidential and secure. Now, the mediator bears the responsibility to pay the risk of online communication to the parties. But of course, parties that it is a confidential. So what some mediators do is, of course, before the mediation process, the mediators, firstly, they use a unique upgraded subscription plan to provide additional security. The other one is they scan the room. They scan the room, and the mediator has a look. The other parties can have a look as to who is sitting in the room. The other thing is for the mediator to set ground rules. Set the ground rules, confidentiality at the beginning, and make parties commit rules that they will commit to mediate and quiet space without any interference and with walking in or recording the sessions, because record the sessions even though you're not the host by using rights. And the mediator can also during caucus, during the caucus sessions. So there will be confidentiality there again. And if for whatever reason thinks that someone else is in the room, the mediator the session and restart the session later. These are some of the things which the mediator can ensure to ensure confidentiality. I see a lot of chat that my voice because I think my internet connection is not clear. I will shut my video so that maybe you can hear me better. There's definitely a network issue. Yes, sorry. Right, I hope I've stopped. Hopefully you can hear this better. Right, let's move to private data security issues. Now, cyber security is a debatable. So although security and encryption technologies all the time, the internet can still be a porous place when it comes to security of data transmitted electronically. Online service providers must ensure information shared with them should be protected and encrypted. And providers may also store in the cloud. So it is pertinent that cyber hackers steal information. So cyber scams like spoofing to steal information. If there's a breach, this may tarnish the service providers. So adherence to data protection, including safe storage and established protocols to and cyber attacks, is very important. So cyber Zoom bombing, when an unwanted guest joins the parties, serious threat to the confidentiality of the process, privacy of the parties, and security of their personal and financial will also be a danger of being hacked, right? One of the solutions I can suggest is for local privacy statute to provide for all this and to enable the client to enforce confidentiality and privilege. I will move quickly. We don't have much time. Disadvantage is communications or managing communications. As I said just now, of communication is non-verbal and face-to-face is so simply allowing disputants to exchange messages actually deprive the mediator of showing off some of his expertise. I think some of the solutions which you can use for communication, this disadvantage is it may be mitigated through the increase of tools like focus session, having more focus, checking in with parties on how they feel. So at least the mediator gets to empathize with the parties or share their feeling discomfort. And the next disadvantage is distraction. Parties may also become more easily distracted on an online platform because they can be distracted by dogs barking, all these can, and a party can also distract himself in an online environment as a form of passive disengagement from the negotiations. He might just choose to keep quiet. Difficult for the mediator to pick up on this disengagement negotiations in an online session, impacting communication. And lastly would be enforcement issues of mediated settlement agreements. Now, individuals in India seeking to accord mediations have the advantage of having the Arbitration Act 1996, which I think is a fantastic provision. Section 30 actually provides that all these, even things like online mediation, can be recorded and be enforced as a normal court order. So this is a fantastic act which actually assists parties in India to enforcement for the parties, which may not be available in other countries. We do not have such provisions in our Mediation Act, have a Mediation Act. And the next significant step is of the Singapore Convention, where if India ratifies the convention, we are all signatories to the convention. If ratify it, will be a huge step for everyone, because this will help international Lastly, I would just like to touch on the impact on ODR. Very quickly, in AI have actually gained traction in the field of ODR. Questions have emerged whether an algorithm will be able to read human interaction and decision making. So AI will be used as a mediator, and human professionals may not have a significant in the dispute resolution process. So what's going to happen to mediators like me, mediators from Nivaaran? Are we going to be out of a job? Let's hope not. I still think there will be a demand for mediators like me and all our mediators out there, because we will continue to play a role in mediation, because firstly, not all disputes are suitable for online mediation and by using AI methods, because face like family disputes, it is extremely important to show. I don't think AI would be suitable. That's my personal view. Even to design an AI platform for mediation, I think lawyers like us will still be in demand to use the available AI tools smoothly in order to come to a mutual agreement. So online mediators for the job. I think online mediators will still be in demand or assistance sought from us to design AI tools for online mediation. So I think with that, let's wrap up by talking about the future and online dispute resolution, online mediation. And I think the world has changed radically since last year after the COVID-19 wreaked havoc around the world and still continuing to do so. And work from home is now the new normal. So every technology is changing at such a rapid pace, and the growth of online dispute resolution has grown by leaps and bounds, if I may say. Unless your conflict can wait, then you don't use online and resolve your dispute. But for now, I think everyone to resolve their disputes by way of online, because we really do not know going to go back to normal times. And, I going to be very difficult to go back to where we were. And it's a very challenging time. And post-pandemic, so what's going to happen post-pandemic? Are we still going to use online methods disputes, or are we going to Zoom or not to Zoom? We may just revert back to our old ways, but I really don't think so. I think we still continue with online methods of resolving this. I think AI will have a big part to play in it. And the takeaway I would say from this session for all participants would be that online mediation, online dispute resolution methods works. Although there are differences in online mediation, I think the advantages outweigh the advantages. So we should not be afraid to use this platform to resolve disputes. And last, end with a quote which says, time when people felt the internet was another world, people realize it's a tool that we use in this. Thank you very much for listening. I apologize if my voice was breaking up because of unstable connection. I hope you all enjoyed the session, and I hope the students will now participate by asking questions or posing questions for this session. Thank you very much.
Thank you, Gunavathi. Am I audible?
Yes.
Yes. So with your permission.
I have turned off my video because I think
yes,
voice...
I know. So that is a very big concern with the students and with us also. And I really request the organizers to give share the PPT as well as the session, the recording. That's what everybody wants it. And now I will be taking up the questions. Being students, they are very much eager to have to know about the internship opportunity. I have seen one or two questions regarding this. So that also I do not know how to, we cannot, answer that one by one. So I will be taking up the more general questions. Okay. So one question is this: non-verbal communication may not be captured in ODR. Maybe it is good for commercial, impersonal disputes. Your take, Gunavathi. Should I repeat again? Non-verbal communication may not be captured in ODR. Maybe it is good for commercial, impersonal disputes.
You're breaking up as well, Sangeeta.
Oh, I am also breaking up. I don't know.
So I think one of the stages which I spoke about is that communication may be different in an online scenario.
No, then
non-verbal. Yeah, it's better now, I think. Yeah. So I think the question is, because of the non-verbal communication which in an online scenario, what happened suitable for all type of disputes? I think that's the question.
Yes,
so to answer the, I would say yes, but with practice, of course, you can. I think mediators can pick up more than inexperienced mediators, whether or face to face. But of course, I am not saying that it can be. It is the same. It's definitely not the same. So many disputes where you need to show a lot of empathy and have more reading of non-verbal signals which are sent participants or the disputants, then I think maybe may be more suitable. But having said that, I think if it's not such an acrimonious between the parties, let's say it's just about maintenance, can also be acrimonious, then maybe certain things, then it's suitable. But if it becomes really, maybe family disputes should be taken face to face. But for commercial disputes, definitely suitable, because I think more of the signals, non-verbal cues are very important for family disputes.
So should I go to the next one?
Yes, please.
Are there any prerequisites as to qualifications to apply for the mediation trainings at different mediation center, specifically Malaysian mediation center?
Sorry, again, Sangeeta, sorry.
Any prerequisite of qualification? What are the prerequisite qualifications to apply for mediation training, particularly in Malaysia?
Right. Okay. In Malaysia, we have a mediation center. And the prerequisites, normally you have to be a professional. So it's not open to I think that is what they want to know. So it's not open to students. Started off by limiting it to who were more than 7 years in practice. Away with that rule. So even young lawyers can now apply to become mediators. And of course, you have 40-hour training session at the mediation. And of course, there are different as well around the country. I conduct my own training session as well. My of accreditation come from the university because I teach at the university.
Okay,
that come from the universities.
The next question: how signatures of parties can be taken online? What is their authenticity? I would like to put in a point that digital signature is the norm now. I think is commonplace.
Yes.
Your take,
Yes.
Gunavathi.
Yes, digital signatures are. Yes. The next question, Sangeeta.
May advocate or professional, many, I think this is a very, I cannot understand. Many advocate or professional attend with one party without knowing the mediator. This will be unfair and imbalanced. How can we avoid this problem? I have asked the gentleman to clarify the question, but I have not yet received.
Sorry, what's the question?
The question is, where this? So if an advocate or professional attends with one party without knowing the mediator, this will be unfair and imbalanced. How can we avoid this problem? I think he must be asking about the imbalance, power imbalance.
Power imbalance.
In general.
I think it is one party, the other party doesn't have a lawyer. Because otherwise,
yes,
how is that?
Correct.
Is the question. So to answer that question is, I have come across as well when I was mediating. Normally, I will parties if they are comfortable with it, and if they are unsure, I would tell them that perhaps they should a lawyer to represent them because one a lawyer and the other party doesn't. So that's how you try and balance. But sometimes the parties may be adamant and they will say, no, I don't lawyer because I don't want to waste money. So he may say, if the party knows what he's going into, then up to him, but I would definitely caution the party.
Okay, can I take the next question, Gunavathi?
Sure.
Is ODR just the online version of normal ADR, or is it the resolution mechanism for online disputes? Please clarify. Is ODR just the online version of normal ADR, or is it a mechanism for separately online disputes?
No, as I said,
yes,
we even have disputes not only for synchronous and asynchronous, right? And also it can offline disputes and online disputes. So it doesn't, you can do vice versa as well. So you have offline disputes which exist, mediated online. I think that is the question. Not
another question that how artificial intelligence helps in mediation only on ODR. I think many of the questions, how artificial intelligence, AI, helps in ODR, only on online mediation.
Because AI has not developed to a very large extent. You cited some of the sites, some of the service AI providing online mediation, but do not know, but I think that is the future and that is the way to go. think they will have to develop more sites. We do not have any sites
Correct.
in Malaysia so far.
Correct. So
Okay.
there are so many sites, I mean, sort of some kind of self-education through the internet surfing. I think it helps a lot.
Yeah.
Last question I'll be taking here, and after that I will be taking 2 raised hands. This is an important question, Gunavathi. Since settlement agreements can be enforced in a court of law, should one include a governing law clause or jurisdiction clause in a cross-border settlement agreement?
Oh, it's a very...
Yes.
So if I were one of the parties, I would include it in the agreement, so that to give clarity to the agreement that I am here and Sangeeta, you are in India, they've entered into a settlement agreement. I think we should include in the agreement, once our dispute is resolved, we will abide by our consensual agreement, and that any jurisdictional issues regarding this will be the agreement which we are entering into.
There are judgments also on this.
Possible.
There are judgments also on this jurisdiction issue. So let us not go into that. Mr. Srirag Shalan, kindly unmute and you can ask your question.
Hello, am I audible?
Yes.
Okay, good evening everyone. Good evening, ma'am. It was a wonderful session.
Good evening.
Ma'am, my question is today's India ready for online mediation? Because we have close to 90% of our population who do not have any sort of digital literacy, and a huge proportion of them are also below the poverty line. And if I have to speak for the 10% who have any means of access to internet, it is not necessary that need to be digital literate. For example, if an elderly person is using the computer, he would usually need someone to, a younger person to help him around to meddle with things. So the 2 questions are, how far behind is India when we compare globally in online mediation? And in the second situation, as I said, about someone being helpful in the whole computer thing, would the room be holding any modes of privacy? I mean, privacy is actually a huge issue when we come to online mediation.
Correct.
Other than the computer, the virus, or the hacking factors, the room where the person is, if it's an elderly person. So this is my 2 questions. One thing is, how far behind are we when we compare ourselves globally? And secondly, about this privacy issue, especially in connection to the digital literacy.
To answer your first question, I think Malaysia is also very far. Not only India. I think we are worse. We only have one ODR service provider, which was set up in 2016. And 2017, I set up my own online site and as a service provider, and shut it down because the response was so. So I mean, I had to for reasons to shut down my website and to provide the service. There were no takers. So when you talk about India, it's not bad, I would say, because you have already in existence so many service providers offering which we don't have. But of course, like in China, they have their own. In Asia, of course, Singapore is very advanced. We touch Singapore or compare with Singapore in any way. Looking at all the other countries, maybe India is, I think,
there are many. I would like to put in, there are many ODR service providers here in India. And it is not necessarily that you have to have a 5G or 4G connections. We are doing regularly ODR cases through voice calls, through WhatsApp. I mean, minimal, whatever we can do. It can be scalable. Pooja Deshpande, I have been asking her to unmute, but I don't know whether she's there or not. So if actually we are almost done.
Yeah, I think so.
So all queries raised here could not be taken up today. So, but I believe Nivaaran will continue giving us all the opportunities to interact through such events in the future. Ma'am, it is wonderful to have you today in this great session. Taken into consideration all the technical glitches or whatever it is.
Yes.
Furthering the first session's idea of time travel through centuries behind us, when Uma had taken us to the history of mediation. This session, I must say, is a time travel into the future of ADR. But often we find it difficult to get the parties on board to agree, even to mediate, even to come and communicate, especially in private mediation or pre-litigation mediation. So, before approaching the adjudication process, parties must be advised to go through mediation process, at least through ODR. And this does not take away the voluntariness of the parties, take away. Here, the advocates play a much greater role so as to help create the required comfort level of the parties. So in the final session tomorrow of this wonderful virtual summer school, we will learn about mediation advocacy, where you will have Mr. A.J. Jawad as the guest speaker and Ms. Varuna Bhandari as the host and moderator. I must thank Nivaaran to give us this opportunity, and our IT person, Mr. Rahul Kumar, who despite his ongoing busy schedule, helped us all to reap the benefits of these wonderful sessions seamlessly without technical glitches. Here and there it is okay. So finally, thanks to Nivaaran's senior members, who as a team becomes the backbone of Nivaaran and brings it to this great height, of course, with much needed support from all supporters, all the quarters. We will wait for all of you tomorrow at 5 p.m. sharp. Thank you. And I'm very sorry that we could not take up all the raised hands. Hope you can understand. Thank you.